In Texas, interestingly, employers do not have to carry what I would call standard workman's compensation. And that's important because if an employer gets standard workman's compensation, which is expensive, then if you're injured at work, you can't sue the employer. You're going to be limited to going through the workers' comp system, where there's a bunch of doctors that, in my opinion, aren't going to be very fair to you, and their goal is going to be just to get you back to work as quick as possible, not necessarily care for your injuries. Now, some employers try and save some money, and they carry something called non-subscriber insurance for work injuries, which is also known as non-standard workman's comp. And there's an important distinction there. There will be a benefit plan where you can collect benefits for your injury, just like you would under workman's comp. But if they choose not to opt into the Texas workman's compensation system, if they choose to be a non-subscriber like Amazon, Walmart, H-E-B, Lowe's, and many other large companies, in addition to everything under that benefit plan, you can also sue them under the common law for mental anguish, pain and suffering, full lost wages, and a whole lot more than you would ever get under workman's comp or the benefit plan they're providing you. And most importantly, in a non-subscriber claim, you can see doctors that are outside of that benefit plan who may give you a much fairer opinion about what the future holds for you. And you can hold your non-subscribing employer responsible for those damages, regardless with whether or not the company doctor that was handpicked by the company agrees you're going to have those problems. If you do have a non-subscribing employer and you sue them for these additional damages, they can't claim you were negligent as a defense. So you could be 99.9% the reason you got hurt at work. If we can show your employer was 1% negligent, you will recover 100% full damages. We're asked a lot how to figure out if your employer is a non-subscriber, and it's pretty simple. If you get on Google, you can Google Texas non-subscriber verification, and it'll actually take you to the Texas Workers' Compensation website, where you can type in the employer to verify whether or not they actually carry Texas workers' compensation, or if you're dealing with an employer that doesn't have Texas workers' compensation. But if you want to do it the easy way, just give us an email or a call, and I'll be happy to tell you if your employer subscribes, because we keep a pretty accurate list that's up to date. People sometimes want to know if evidence of an injury medical records are required to prove your injury. And the simple answer is, the more documentation you have of how you were hurt, when you were hurt, and the problems that caused you, the better. So I urge all my clients to get to a doctor, and not necessarily the company doctor that just writes injured at work, to a doctor that's going to give you a very detailed assessment and take a detailed description of the mechanics involving how you got hurt, in addition to all of the injuries involved, and do tests that confirm your injuries. Schechter, Schaefer & Harris has been handling non-subscriber cases for decades now. We've taken these cases to judgment, and we've also handled them against some of the largest employers in the state, such as Home Depot, Lowe's, and lately a lot against Amazon, who've chosen to go this route of not carrying standard Texas workman's compensation. And I particularly like these cases. They are very, very favorable to the worker. But interestingly, the people who work at these companies, until they contact us, they don't know that. Our current and past clients would say that we care about them, that we've worked hard on their case, no stone unturned. But really, I would urge people to go look at our reviews and see what our clients say, because they really speak for themselves. And on our website, we also have some testimonials if you want to watch a video and hear from someone in person. At Schechter, Schaefer & Harris, client communication is our #1 metric. In fact, we have a policy that every client will be spoken to every month. And at the beginning of a case, I'll tell you, we're probably speaking to you every day. We make sure that the attorneys and the case managers are calling the clients back. The attorneys and case managers are also provided a list every single week of clients they haven't spoken to in the last 3 weeks. So it's crucial that we talk to the clients to make sure their medical care stays on track, to make sure that their case development is moving forward. And most importantly, the clients want to hear from us. So we want to be talking to them and keeping them informed what's going on with their case so they're comfortable with the process. Here at Schechter, Schaefer & Harris, we're a medium-sized firm, and that has advantages. If we were really, really large, you would have all sorts of red tape and all sorts of levels of people you probably had to deal with to get your case resolved. On the other hand, if we were a sole practitioner with 1 or 2 legal assistants, you'd probably have an office of people who are overwhelmed and can't get to everyone and service the clients properly. I would call us a medium-sized firm. We're in the middle. And the way we divide things up is we assign a lawyer and a case manager and a paralegal to each of the cases, so every single case is getting adequate attention. What makes us different than other firms is we're real trial lawyers that are really going to handle your case the way a lawyer who might end up in court on your case would. Now, that's not to say every case is going to end up in court, because the vast majority of cases, especially if they're prepared properly, do settle. But it is important to have lawyers with a track record, and lawyers that actually try cases, and lawyers that are known to the insurance companies and the defense as willing to go to trial on your case to get the top value. During your initial consultation for a Texas 9 subscriber case, we're going to be asking you a lot of questions about how it happened, because that's the threshold. We've got to show just a little bit of negligence, but it doesn't have to be a lot. So we're going to be asking you, was there any involvement of your coworker? Because if your coworker had just the slightest involvement in causing you to get hurt, well, that establishes negligence, because your negligence would not be a defense. We're going to be asking you about the policies and procedures at your place of employment, because if your employer was negligent in the slightest way in monitoring or training you with regard to how you got hurt, that may be enough to establish negligence. So we spend a lot of time at the beginning before we accept a case, asking all the right questions so we know we can succeed and prevail and win at the end.